Okay. For the visitation, who would you like to supervise the visitation?
It could be myself or my friend if I didn't need to be there. So it could be either one of us.
Who, who is your friend?
Christopher Whitley.
Your partner to take testimony as to whether they accept service from the state.
Okay.
Mr. Jones, can you please state your full name?
Charles Jones.
Mr. Jones, did you receive a copy of the state's petition in your email today?
Yes.
Do you understand that you have the right to be personally served with that document?
Yes.
You waive that right today?
Yes.
Do you understand that you have the right to request a reset and file an answer?
Yes.
You waive that right today?
Yes.
And are you in agreement to proceed today?
Yes.
Your Honor, I request that the record be updated to reflect that Mr. Jones waived his rights to personal service and citation.
So noted.
Ms. Mayfield, can you please state your full name?
Armatha Mayfield.
Ma'am, did you receive a copy of the state's petition in your email today?
Yes.
And do you understand that you have the right to be personally served with that document?
Yes.
Do you waive that right today?
Yes.
Do you understand that you have the right to request a reset and file an answer?
Yes.
And are you waiving that right?
Yes.
Your Honor, I request the record reflect that Ms.
The hearing opens with procedural clarity. Both parties acknowledge receipt of the state's petition and formally waive their right to personal service. Each confirms understanding of their rights, including the option to request a reset or file written answers, yet both choose to proceed immediately. With these waivers entered into the record, the court establishes that this is a fully contested petition to determine the parent-child relationship. The foundation of the case is set carefully, emphasizing due process before substance. Only after these formalities are resolved does the court move forward, signaling that every step taken today will carry legal weight and lasting consequences.
Mayfield has waived her right to personal service and citation.
So noted.
Okay. This is a fully contested petition to establish the parent-child relationship. So I'm going to call Miss Mayfield again. Miss Mayfield, can you state the name and age of your child?
Basima Mayfield, she's 6 months.
And who is the father of this child?
Charles Jones.
And were you ordered to take DNA test?
Yes.
Your Honor, may I share my screen?
Yes, ma'am.
Okay. Miss Mayfield, do you see this DNA test?
Yes.
Do you see your name?
Yes.
And do you see your child's name?
Yes.
And Mr. Charles Jones' name?
Yes.
The mother testifies first, identifying the child as 6 months old and naming Charles Jones as the father. A court-ordered DNA test is presented, showing a 99.99% probability of paternity. The exhibit is admitted without objection. She confirms the child is currently covered by Medicaid and requests sole managing conservatorship. When asked why joint conservatorship is not appropriate, she explains that the father has not been involved emotionally, physically, or financially since the pregnancy. Communication between them has been non-existent, and contact ceased after paternity was questioned. Her testimony centers on consistency, stability, and the child's young age.
And you see here where it says the probability of paternity is 99.99.
Yes, ma'am.
Your Honor, may I stop sharing my screen?
Yes.
State would like to offer this paternity test as State's Exhibit A.
State Exhibit A is admitted.
Thank you. Ms. Mayfield, how's your child covered for insurance?
She's covered through Medicaid.
Ma'am, are you asking to be named sole managing conservator?
Yes.
Why are you not in agreement to be named joint managing conservators with the father?
Because since my pregnancy was confirmed, Charles Jones has not been involved emotionally, physically, or financially up until this present day.
Do you two communicate amicably?
No, the last conversation that we had was when he insinuated the paternity of the child. And from there, I was blocked on his social medias. So we haven't had any contact at all.
Discussion then turns to visitation. The mother agrees to future visitation but asks for a phased approach, citing the child's age and lack of familiarity with the father. She proposes supervised visits initially, naming a family friend as a potential supervisor. She clarifies there are no safety concerns or allegations of violence, only a desire to establish routine before unsupervised contact. Locations suggested include neutral public spaces such as parks.
Are you in agreement to designate the child's primary residence in the Dallas and contiguous counties?
Yes.
Okay. Are you in agreement for the father to have the state standard possession?
Can you clarify what that means?
Are you in agreement for Mr. Jones to have visitation with the child first, third, and fifth weekends of the month from Friday 6 p.m. to Sunday 6 p.m.?
Only after supervised visitation is occurred, yes.
After supervised visitation has occurred?
Yes.
Do you have safety concerns with Mr. Jones?
It's just for the betterment of the child because they don't have a relationship at all, and she's still so young. So I would want that consistency to be established first before after the visitation on his own.
How old is your child?
She's 6 months.
So you're wanting to have step-up visitation for some period before Mr. Jones can have the state standard?
Yes.
Okay. For the visitation, who would you like to supervise the visitation?
Financial matters follow. The father's income is presented, and guideline child support is calculated accordingly. The mother agrees to the proposed monthly child support amount, cash medical support, and a structured repayment plan for retroactive support covering 7 months. These figures are entered clearly into the record. Attention then shifts to the father's testimony. He acknowledges the DNA results and agrees to the child's hyphenated last name. He confirms his employment and lack of access to affordable private health insurance, consenting to continuation of government medical coverage. Financial obligations are addressed methodically, reflecting statutory calculations rather than negotiation.
It could be myself or my friend if I didn't need to be there. So it could be either one of us.
Who is your friend?
Christopher Whitley.
Your partner?
No. It's a family friend, yes.
Is this someone that Mr. Jones is familiar with?
They've met before, but this is also someone who is kind of in the parallel of how much time I spend with her. They spend that just as much time with her, and they pick her up from daycare, all those things. So they pretty much know her routine and everything.
Do you have someone else, like a parent or another competent adult that Mr. Jones is more familiar with?
No, that's been the only person that he's set eyes on that he's familiar with or aware of.
So Mr. Jones doesn't know your parents or any siblings of yours?
No.
Okay. And for this supervised visits,
The father objects to paying retroactive child support, stating he only learned of confirmed paternity that day. He acknowledges being informed of the pregnancy but admits he did not independently pursue paternity testing. He expresses willingness to assume responsibility moving forward. When conservatorship is discussed, he requests joint managing conservatorship, though he confirms he has not interacted with the child or participated in decision-making. He initially resists supervised visitation and requests standard possession. Under questioning, he concedes unfamiliarity with the child's routines and agrees to a brief phased visitation plan, though he raises privacy concerns regarding proposed supervisors.
Would you be in agreement to do maybe Saturdays from 12 to 2 for a month?
Can we extend the time frame?
Okay. Can you explain what you're envisioning then?
Because I'm really going in blind, so I don't really know how consistent or not that Charles Jones will be. So I would feel more comfortable at minimum to a year or 2 years.
You want him to have visitation Saturdays 12 to 2 for 2 years?
Yeah.
And supervised by your friend. What's your friend's name?
Christopher, spelled CHRISTOPHER. Willie, WILLIE.
The court reviews the evidence and issues findings. Paternity is established, government medical insurance is ordered, and no family violence is found. The child's name will be changed through a separate administrative process. Child support, cash medical support, and retroactive support are formally ordered. The judge explains that responsibility begins at birth, not at confirmation. Sole managing conservatorship is granted to the mother.
And where would you like for this visitation to occur?
It can be any neutral place, like a park or Katy Trail, wherever. It doesn't have to be like one set place every single time, just a neutral place.
Is there a place by your house, like a park, that you would be comfortable with?
I live near the Katy Trail. That's like the closest thing I can think of.
Katy Trail Park.
Mm-hmm.
Okay. Would you be an objection after the child turns a year for Mr. Jones to have an overnight visit?
Not if consistency is shown, no.
Has there been acts of family violence between you and Mr. Jones?
No.
In the last 2 years?
No.
Do you have any safety concerns if Mr. Jones has your address or phone number in today's court records?
No, not anymore. I believe I don't know if he still has it at his disposal or not, but no.
Okay, so your main issue with Mr. Jones having possession and access is you'd like for Mr. Jones to get to know your daughter more.
Yes, because
and it's not because...
I'm sorry, go ahead.
And it's not because you have safety concerns?
No, it's just simply establishing that, because the last that I was made aware of by him was that he wanted absolutely nothing at all to do with her. So I was just, yeah.
So just to be clear, you're just wanting to establish a routine, and then after a routine is established, then you would be in agreement to the state standard possession?
Yes.
Okay. Are you in agreement to a change of last name to Jones for the child?
I'm okay with a hyphenated last name.
So you would be in agreement to do Mayfield Jones?
Yes.
The father currently works at $8.25 an hour, and the state calculated his gross income to be $1,430. State's asking to set child support at $236 a month beginning September 1st, 2025. Are you in agreement to that?
Yes.